The defense agrees to settle your case for $5 million. You and your attorney are thrilled. You accept the defense's offer. And now, before you have a chance to sign off on all the closing documents that formally settles your case, the defense lawyer calls your attorney and says, listen, I have some bad news. We are rejecting our offer, and now we expect to go forward to trial. Can they do that? Do they have the ability to go ahead and withdraw the settlement offer that you agreed to verbally? Would you like to know the answer? Come join me for a walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. Can they do that after making a substantial settlement offer, and now you and your attorney having accepted that particular offer verbally? The short answer is yes, they can do that. Is it done often? The answer is no, it's not done. If something like that were done, that, in my opinion, would be acting in bad faith. That, in my opinion, would be a settlement offer, and now you have a withdrawal of that offer. And there's various elements of contract law that applies when an offer is made and when an offer is accepted. Here's something technical that you may not know. In order to really enforce a settlement, now the parties have to ensure that the terms of that settlement are recorded, they're written down, and they are exchanged and agreed upon by each side. That is the best way. Well, I shouldn't say the best way. The best way is to agree to a settlement in open court and have the judge question you as the injured patient, as the injured victim, and now the attorneys will agree to the terms in open court and have it recorded by a court stenographer in court. That is the best way to effectuate and to make a settlement happen. The second best way is now to put everything on paper that the attorneys have agreed to, especially the terms of the settlement agreement and the offer and the acceptance, as well as the timing in which the paperwork has to be filed, as well as the timing in which the closing documents have to be presented to the defense, and how much time the defense has in which to make payment after receiving all those closing documents. Now, if they were to back out after everything is documented like that, they're going to have a much harder time to back out of a deal, as opposed to a verbal agreement. Now, that's not to say that you can't enforce a verbal agreement. Now, there are very specific circumstances in which it can be honored, and there's very specific circumstances in which it will not be honored, and the defense will be able to go ahead and back out. You should know that there are repercussions when this happens. And one of the biggest repercussions involves credibility, especially between the defense lawyer, the plaintiff's lawyer, and each of their firms, as well as their principals. It will create very hard feelings that will not likely be repaired for many years to come. The defense may withdraw an offer for various reasons. Maybe they have a change of heart. Maybe their client has a change of heart. Whatever the reason is, now after making a good faith settlement offer, they back out, and now they're going to have to risk the consequences. And one of the biggest consequences is that now we have to go to trial, try the case, and if, in fact, we get a verdict substantially higher than what the settlement offer was, now the defense will likely want to negotiate from that number. And at that point, there are going to be very difficult challenges. And in my opinion, if that were to happen, your attorney likely will not want to go ahead and start to negotiate. He's going to try and push them to get the maximum amount possible, either through a negotiated settlement or by taking it up on appeal and now being successful with the appeal. So why do I share this quick information with you? I share it with you just to open your eyes and to help you understand how these types of cases work in the state of New York. You know, I realize you're watching this video because you like the music in the background. No, I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in the state of New York, and you have not yet started a lawsuit, but are thinking of doing so, and still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every day, and I'd love to chat with you. You can reach me at 516-487-8207, or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.